So what is it about presidents and the Supreme Court? What connection can we draw here? Well, I think it is based on the fact that our nation was founded on the rule of law. Interestingly, of the 44 occupants of the White House, or presidents, because they didn't all get to live at the White House, but of the 44, 26 have been attorneys. And 8 of those 26 have actually made arguments in the Supreme Court, either before or after their presidencies, or both. And so if we could go to the next slide, Jonas, arguing in the Supreme Court is considered the pinnacle of a legal, in the legal profession. So it's quite an honor and challenge to do this. I think I would be horrified, totally intimidated. But I wanted to show you that in the course of the Supreme Court history, there have been several courtrooms, not the one that we have today. So I wanted to show you the courtroom that was initially used. For the first 150 years, it was located in the Capitol. And this room, it looks very bright and cheery here, but actually it's below ground. It was rather dark. And you can see there are, yeah, I think it has 7 chairs, because that's the number of justices at the time. It's not the 9 that we have today. So how does someone qualify? You know, not anybody can just appear in the Supreme Court. You have to be admitted to the Supreme Court bar. It has its own qualifications that are pretty standard, I think, with what other bars are like. In every state has their own qualifications, but you have to show that you are knowledgeable in the law by having 3 years experience in the highest court in your state. And then you must be recommended by someone. You have to be nominated and swear to the court that you believe this candidate is of good character and good standing. And then you also have to pay a little fee. I don't know if that's always been the case, but that's what you have to do to qualify. Now, how do you get a legal education? Well, in the early days of the United States, there were very, very few law schools, very difficult to find one. And so it was an apprenticeship. You would read the law. You could either do it on your own or in a law firm, if the attorney was willing to take on that responsibility. And then you still had to pass an exam. And the exam was rather cursory in some instances. Maybe you took a walk with a judge, you had a conversation, and they'd say, okay, you passed. So things have gotten a lot more formal. But in this particular courtroom, we're going to see where our first 3 presidents made their arguments. Before we move on, though, I said, well, what is it that the lawyer actually does? And please forgive me if this sounds basic, but you're arguing on behalf of your client, whether it's the respondent or the petitioner. The petitioner is the party that wants to be there. The respondent was happy with the judgment down below. And so how do you present your case? Well, you have to state the facts as well as the law. Today, there is, you write a brief. That was not a process that was in place when the court first began. The court, by mid-19th century, did require that there be something written that they could review ahead of time. Also, when arguing before the court, and you can see these green tables on the left, that's where the attorneys would have sat and gotten up to make their arguments. So the arguments, time was unlimited. There was no clock watching until, again, 1849, when it was 2 hours per side. Then it later became 1 per side. And now, since 1970, it's 1 hour for the total case, however many parties are participating. So the justices have become more reliant on the written materials. So being a good writer and a good orator do make a difference in being a Supreme Court advocate. And oratory back in the 19th century was very different than it is today. Rhetoric was very emotional, very flowery. Today, it's very succinct and direct. So stylistically, that has changed as well. So let's go on to meet our first president. If we could have the next slide, please, Jonas. This is John Quincy Adams. He actually argued 5 cases in the Supreme Court. He really didn't like the law. He found it rather boring. He was an intellectual. He had a lot of diplomatic experience traveling with his father. He spoke 5 languages. And he wound up becoming the senator from Massachusetts in 1804. And in 1809, he is arguing on behalf of Mr. Peck in Fletcher v. Peck. Here you can see, I tried to get images of the presidents around the time that they were arguing the particular cases. So here he is in a lovely little silhouette from 1809. Now, what was this case about? Can you see there's a map here? It's the state of Georgia. And all this land to the west, it's basically what became Alabama and Mississippi, all the way to the Mississippi River on the left. All of that land was claimed by Georgia, and it needed money, so it decided to sell off this property. And Mr. Peck was one of the purchasers. And it turns out, when it was learned that the legislators had actually been bribed to sell the land, the legislators were kicked out, new ones came in, they rescinded the law and revoked all the transactions. So Mr. Peck, who lives up in New England, had sold some of his shares to Mr. Fletcher. And Fletcher is suing because he said, this contract has no value. It's, you need to pay me because you sold me something that is worthless. So the issue before the court was, is this a good contract? And was it viable? The outcome of the case, first of all, when John Quincy Adams argued it, it was in early March. And he made a very good argument, and the Supreme Court ultimately adopted his argument and said, no, the contract, even if it had a bad intent, under the Constitution, the contract clause, this is a legitimate contract. And it also asserts for the first time, which makes this a very significant landmark case, setting the precedent that the Supreme Court could oversee the constitutionality of state laws. And that was significant even today, because that's the same concept that lies behind Brown v. Board of Education and even Roe v. Wade. So the consequences, we're still experiencing them. A little footnote about when Adams was arguing, it happened to be Inauguration Day. So the court took a break. They went to see President Madison sworn in, and then they all came back and continued their argument. So this was land titles were a very, very big issue in the early days of the country. As you can imagine, the country is growing, expanding, and settling lands that had never been settled before. So what a great start to his legal career in the court. And if we go to the next page, next slide, we'll see he had another very exciting case involving the schooner Amistad. These were Africans who'd been kidnapped, and eventually some Spanish planters took them over in Cuba, and there was a revolt on the ship. They killed the captain, and they thought they were going to be to Africa, when lo and behold, they wound up in the United States. They were taken into custody, and it then became a rather complicated case because there was the Spanish interest, there were treaty issues, maritime issues, but the bottom line was, are these Africans free or are they slaves? Are they property and need to be returned, or can they go home? The interesting thing is they were represented, and you can see Joseph Cinque, that was a name given to him, was the leader of this group. He had learned English and he was able to testify at the initial trial, and that court said, yes, they should be free. It went up on appeal. that court as well said, yes, they're free. But it's 1840 and Van Buren is running for president again, re-election, and he needs the support of the Southern slaveholders. So he gets the United States to appeal the case. So it's in the Supreme Court. And if we could go to the next slide, please, Jonas. And you will see, here's Quincy Adams, 1843, not long after he'd argued this case. And this is the first known photograph in the Portrait Gallery's collection, or that is known to be of a president. And the gentleman on the left is Joseph Story, someone who had argued in Fletcher v. Peck along with Adams, and he is now on the Supreme Court. He is the one who actually hands down the opinion saying, yes, these individuals are free and should be returned. So I thought you might enjoy seeing a bit of the reenactment of this that was in the film made by Steven Spielberg about the Amistad case.
In the case of the United States of America versus the Armistead Africans, it is the opinion of this court that our treaty of 1795 with Spain, on which the prosecution has primarily based its arguments, is inapplicable. While it is clearly stipulated in Article 9 that, and I quote, seized ships and cargo are to be returned entirely to their proprietary, the end of quote, it has not been shown to the court's satisfaction that these particular Africans fit that description. We are then left with the alternative that they are not slaves and therefore cannot be considered merchandise, but are rather free individuals with certain legal and moral rights, including the right to engage in insurrection against those who would deny them their freedom. And therefore, over one dissent, it is the court's judgment that the defendants are to be released from custody at once, and if they so choose, to be returned to their homes in Africa.
Thank you, Jonas. I get choked up when I watch that. Excuse me. So there you had Anthony Hopkins playing John Quincy Adams, old man eloquent. You know, he had been so, after his presidency, he was in the House of Representatives speaking out against slavery, which is why he seemed the ideal person to help make this argument. And certainly the Supreme Court agreed with him. And it was a very significant case. It was the first time the court had actually reviewed something involving Blacks, that they had access to the legal process. I'm wondering if anyone may have recognized the person playing the role of Joseph Story. It was, in fact, a living Supreme Court Justice, Harry Blackmun, excuse me, who, when a new justice succeeds to the court, they say this was the seat that belonged to a particular justice. And so Justice Blackmun held just Joseph Story's seat on the court. Now, if we go to the next slide, please, you'll see, you know, there's an aftermath to what goes on with Supreme Court cases. Here we have some artworks, a mural done in the 1930s of the trial, and that's a Jacob Lawrence Prince on the right showing the actual revolt on the ship. But even though the Africans had achieved their freedom, how were they going to get home? There was no provision for funding. The president, Tyler, Congress, they were not interested in providing any support. So that picture that we saw earlier of Joseph Cinque was actually created to sell, to raise funds, the missionaries, to help them get back home. And then, even then, John Quincy Adams was still in Congress when twice the Spanish wanted to get some damages, $50,000, $70,000. So he was still there working to make sure that the court's wishes were carried out. So we'll move on now to, that's quite a dramatic beginning for a first president to be in the Supreme Court. The next gentleman we'll see is James Polk. James Polk is there in the center. He came from Tennessee. He's now in Congress. At this time, he eventually becomes Speaker of the House. And guess what kind of case they're considering? It's land claims in Tennessee. And the two parties, one side, they're all Tennesseans. One side has the two senators from Tennessee, and the other side has James Polk, who's in the House, and Senator Thomas Hart Benton, who we associate with Missouri, but he was originally from Tennessee. So they argued the case, and Chief Justice John Marshall, interesting, during the argument raised the question of whether this was similar to Fletcher v. Peck, that case that John Quincy Adams had won early on in 1809. But the court decided ultimately it didn't have jurisdiction. So it didn't reach the merits of the case and sent it back to Tennessee to resolve. Well, it never was resolved. And that's Davy Crockett there on the right, because he was in Tennessee, in the House representing Tennessee, and he and Polk made great political efforts to try to get the House and Congress to resolve the dispute, but they were not successful. And Davy Crockett left and went to Texas and died at the Alamo. So while it was not a significant case, it did introduce Polk to the legal process. What's interesting is the whole land question. Back then, there was a lot of land speculation. People bought land and sold land to make a lot of money, and there was bad record keeping. Titles, deeds to land was actually an American concept. The British didn't have that when we were under colonial rule. So it was a very big deal. But in terms of Polk as an advocate, John Quincy Adams didn't think he was very special. He didn't have any gracefulness of delivery, no elegance of language, that whole rhetoric. He was very direct, and his words carried conviction, and he clearly had command of the facts. And I think that carried over. That's how he was as president. He was a workaholic and wasn't interested in politics per se. So we'll move on to our next president, and that is Abraham Lincoln. Abraham Lincoln serves one term in Congress, 1847 to 49. And are you noticing that a lot of these pre-presidential advocates are in the House and Senate? Well, when the court is meeting the same time as Congress is meeting, and so you just walk down the stairs and you can make a little extra money advocating for a client while you're also legislating. Lincoln is especially skilled. He probably had the most legal experience of any of our advocate presidents. He handled over 5,000 cases. Many were argued before the Illinois Supreme Court. So he was a very skilled trial and appellate attorney. In this particular case, which highlights the way the judicial branch was established back then, is Supreme Court justices were expected to ride circuit. They would go, when the founders were writing the Constitution, they wanted justices to get to know the people and let the people see the people who are deciding controversies in their own area. So one of the justices was Justice McLean, and he was in the circuit, in Lincoln's circuit, and he had overseen, he was the presiding judge in this very same case. And here it now winds up in the Supreme Court, and he's hearing it again. So it wasn't considered controversial, though today we might say, why you should recuse yourself in a situation like that. The Chief Justice in the case was Roger Taney, who, while a very good Chief Justice, has the reputation, a very undesirable reputation because of the decision in the Dred Scott case, basically saying that people of color, didn't matter if you were free or not, were not citizens. And that case actually became the foundation for Lincoln's presidential campaign. And ironically, it was Taney who swore Lincoln into the presidency, gave him the oath of office. So when the justices in the Supreme Court ruled on the case, it was on a technical issue. It was that there was the statute of limitations had expired and there was no reason to be there. So of the 5 cases, this is one that Lincoln actually lost. So if we go to the next slide, by now, the Supreme Court has moved on to a different courtroom. It's a bit larger. There you see a photograph of it on the right. And on the left is a painting done by a woman, I forget her name. But this is the Electoral Commission. Can you see all these men on the left side sitting below the red awning below the balcony? They are 5 members of the House, the Senate, and the Supreme Court, designated by the House of Representatives to decide the election, presidential election of 1876, Rutherford B. Hayes versus Sam Tilden. And you can see the public was there. And this was not uncommon. People loved going to hear Supreme Court argument. Daniel Webster was one of the major advocates, and it was the highlight. So keep this courtroom in mind now as where these next individuals argued their cases. So the first one up, if we move on to the next screen, is James Garfield. James Garfield, there on the right, had served in the Civil War. He had become a lawyer. He studied on his own very later in life. He had been a teacher and a preacher and a legislator, so he certainly knew how to talk. But he gets invited to participate. He's one of 3 attorneys to represent the gentleman on the left, Lambden Milligan. Lambden Milligan was an attorney in Indiana, and during the Civil War, he was part of a conspiracy, the Sons of Liberty, wanting to supporting the South. They were planning an insurrection, and they harbored Confederate deserters. They were arrested, tried in a military court, convicted, sentenced to hang. President Johnson then becomes president, commutes the sentence to life. Milligan then goes to the Supreme Court saying, I shouldn't have been here. To be, the military court was not the right court. And so here you have a military officer participating in this case. Now, this is interesting to me. Garfield had never been in a courtroom before this case, never. He gave one of the most eloquent and learned arguments. I've read it, it's clear, even in today's language, he makes a very good case. And in fact, the Supreme Court adopts his argument and says Milligan should go free. He should have been tried in a civilian court, not in a military court. Again, here we have a landmark case that still resonates into the 21st century. I don't know if anyone would recall the Hamdi case, the American citizen who was, the question became, should he be tried in a military court or not after his being over in the Middle East fighting against the United States. And again, he prevailed in that no, even in Hamdi, citing Milligan, if you're a citizen and under certain circumstances, it's appropriate for you to be tried in a civilian, not a military court. So again, here, a landmark case about the right of citizens to due process, the constitutional right. It gave Garfield instant recognition as a constitutional lawyer. He liked the intellectual challenge and the money that he was making, the additional income. And so he did 11 cases in the Supreme Court, and in fact, probably would have preferred a life as an attorney rather than becoming president. And I don't know if you all would remember that, unfortunately, he was assassinated soon after he did take the oath. While he was an outstanding attorney, unfortunately, when he did pass away, there was no will to process his estate. So we move on next to our first president. He'd actually been president, and then Grover Cleveland had won the presidency twice, but he didn't serve successively. So there was a 4-year gap in between. He is our actual first president to argue before justices he'd appointed. That's Melville Fuller on the right. He was the Chief Justice, and another Justice Lamar. And no one thought to think, maybe this is a conflict, that they owe their job to him. An interesting thing about Grover Cleveland's apprenticeship, when he was studying the law, it was in the law firm of Millard Fillmore, another New York attorney who succeeded to the presidency upon the death of a president. Grover Cleveland was known for having an extraordinary memory. He could plead without notes. His written briefs were very thorough. This particular case, Peek v. New Orleans, came when he was working for a New York law firm in between presidencies. The clients included large companies like J.P. Morgan. And this was the only case that Grover Cleveland handled. It involved a very complex set of laws and changes that New Orleans was trying to raise money, issuing bonds to underwrite building drainage programs because New Orleans was flooding. So there were decades of changes to the law, new areas were added. So it was a complex case, not a significant case, but complex nonetheless. So when Cleveland got up to argue, there were time limits at that point, and it was towards the end of the day. And he looks up at the clock above the Chief Justice, and he said, well, I see that we only have a couple of minutes left. And, if it'd be all right with you, I just want to detain you for a few more minutes to complete my argument. And the Chief Justice, his friend, Chief Justice Fuller, who idolized Cleveland, said very courteously but firmly, Mr. Cleveland, we will hear you tomorrow morning. And the court adjourned. So even being that closely connected, there was no leeway. That's how the court functioned. So he came back. Ultimately, the court ruled against Cleveland and his client. And Cleveland was disturbed that perhaps the court was compromised, or that his having been president and having his colleague, Fuller and Lamar, who actually voted for Cleveland's position along with another justice, but maybe that altered the minds, somehow influenced the justices against his client. So as a result, he decided that he didn't want to risk that for any future clients. And so that's why he only did this one case in the Supreme Court. But Fuller did reassure him that his argument was at the very highest level and assured him that he had done a splendid job in the case. The client itself was an interesting one. It was actually a British firm, John Crossley and Sons. They were the largest manufacturer of carpeting in the world, and they were a very progressive company. They paid women and men the same wage doing the same job, and they also created one of the earliest, if not the first, profit sharing program for their employees. This is back in the mid-19th century in Britain. So that was Grover Cleveland's experience in the Supreme Court. We then come to Benjamin Harrison. Now, you'll notice that these are probably not, many of these presidents are not well known for their presidencies. But Benjamin Harrison became known as probably the best lawyer in the country. And that was owing to many, many appearances in the Supreme Court. I think he handled 15 cases. Before the Civil War, he loved being in the courtroom. He was a very good, tough cross-examiner. He was a workaholic. He even worked in the theater on briefs and things like that, which reminds me, that's a story that's been told about Justice Ginsburg, that she could go to the opera and she'd be writing away. So she was following in the footsteps of Benjamin Harrison in that regard. So his first case in the Supreme Court was in 1870. It was railroad construction bonds. That was a big thing back then. And he won. His second case, again, not a very significant case, but who was his opposing counsel? James Garfield. So we had two presidents working on the same case. But there was a case that actually got him quite a lot of attention. And it was an outgrowth of the Milligan case that Garfield had handled in the Supreme Court. Because Milligan, now that he's free, he realizes, I'm going to sue the government. I'm going to get damages for false imprisonment. And I'm going to sue a whole bunch of folks, including Ulysses Grant, who just happened to be president at the time. So it was Grant who came to Harrison and said, please, please, would you represent us in this trial? And it was a jury trial, and Milligan was seeking $100,000 in damages. Well, ultimately, the jury returned its verdict and saying, yes, you were falsely imprisoned, unlawfully imprisoned, and yes, we're going to give you damages, $5. So in a sense, that was a significant victory for all those 12 defendants. So that shows, how these Supreme Court cases can continue on. And that was something that Harrison handled so adroitly. The case that I'm highlighting here, Fallbrook Irrigation v. Bradley in 1896, again, not a landmark case in the law, but it was a landmark case because it involved the taking of private property for public use. California needed water, irrigation. And so this was one of the first cases that addressed the need for development and regulation of water resources in the West. And if anyone has been to California, I lived in LA and hadn't realized it had been a desert. And the only reason it is so lush is because it took water from other places, even from outside the state. So it was a big issue. I thought you can't see in the portrait of Benjamin Harrison here, but you can see he's surrounded by his law books, and there are bookshelves in the back with his volumes. So he loved being a lawyer, and the cases that he did after he served his presidency actually made him quite a lot of money. His standing was so great, his stature as an advocate. He was earning an average of $150,000 a year. That's pretty big bucks. He also participated in an unusual case, an international case. There was a dispute, an international boundary between Venezuela and Britain, and it invoked the Monroe Doctrine. The commission, which met in Europe, included actually two Supreme Court justices, Melville Fuller, appointed by Grover Cleveland, and another justice. So the Supreme Court was sort of involved there. And I should say about that portrait of Harrison, it was such a significant portrait that there were 4 versions made of it for various organizations and entities. But probably Harrison did more than anyone to help promote the Supreme Court efforts of our next individual, and that's William Howard Taft. Lots of Ohio guys here after the Civil War. And how did that come about? Well, Harrison appointed Taft to be Solicitor General of the United States. That, excuse me, that position is now housed in the Justice Department. It's a very high-ranking position, but the role of the solicitor's office is to argue in the Supreme Court on behalf of the United States. So in the 2 years that he served, he was involved in 36 cases, I think, and he argued at least half, if not more than that, and winning most of them. Now, this is, I should also note, he is the first presidential advocate to be a graduate of a law school. He went to Cincinnati Law School in Ohio, but he was very concerned about his oral skills. Was he going to be a good advocate before the court? And so he writes this to his father, who had once been the Attorney General of the United States. And he writes to his dad, "I have difficulty in holding the attention of the court. They seem to think when I begin to talk that that is a good chance to read all the letters that have been waiting for some time, to eat lunch, and to vote their attention to correcting proof and other matters that have been delayed until my speech. However, I expect to gain a good deal of practice in addressing a lot of mummies and experience in not being overcome by circumstances." So I think that gives you a flavor of what an affable and amiable person that Taft was. And I don't think he had to worry so much. The case featured here also highlights the connection of the Supreme Court with other branches. And in this case, it's House of Representatives. Mr. Ballin was an importer of goods, and Congress passed a law increasing tariffs on woolen products, changing the definition of what qualified. And he is contending here in the Supreme Court that the rules of that were used to determine whether there was a quorum were improper, and so this statute is unlawful, and that was the issue. So who had implemented this new rule? Because the Constitution does say, first of all, to pass legislation, you have to have a quorum. And it also leaves to the House and the Senate the right to create their own procedures. So here you have a procedure being invoked. And Thomas Reed, who was the speaker, and you see him in a cartoon depicted, he was as big a man. William Howard Taft was well over 6 feet, 300 pounds, and Mr. Reed was pretty close to that as well. So these two larger than life, actually larger than life figures. But what Reed was frustrating him is that there was a practice in the House that had been ongoing for decades, where members would be sitting in the House, but when the roll call was made by the clerk, they wouldn't say anything. They wouldn't say present. And that resulted in there being a lack of a quorum, which meant it was very, very hard to get any legislation through Congress. So this is how the minority was exerting its power, the minority rights versus the majority rule. And Reed's solution to this was he said that the chair directs the clerk to record the following names of members present and refusing to vote. So it created an official record in the journal that people were there, so you had a quorum. They didn't necessarily have to vote, but there was a quorum. And so the Supreme Court agreed and with the United States, and it was a unanimous decision. And again, here is a case that may seem rather arcane. And how is it relevant to today? Well, this is the issue that the Senate is discussing periodically about the filibuster. You know, how many people, all the rules that they use to conduct their own business. So Taft had a very substantial, in the 2 years, he was very, very active in the Supreme Court. But after his presidency, he decided, like Cleveland, that because he had appointed so many people to the court, that he didn't want to create the impression of any possible conflict of interest. But he ultimately probably did more to change the court than any president at all, because ultimately he was appointed Chief Justice of the Supreme Court. And so when we go to the next slide, you'll see what resulted from that. The courtroom that exists today, the building, was something that Taft lobbied Congress for, not only for a building so that the court could finally have its own independent edifice, but also getting the Congress to give the court discretion on what appeals it could hear, because prior to that, they were swamped with a lot of things. And the kinds of cases that the Supreme Court hears has changed over time. It is Congress that decides what the jurisdiction of the Supreme Courts and the judiciary will be. So many, many changes over the court's history. But nonetheless, this is the courtroom that's in use today. It's very classical in style, Beaux-Art. And you can see the 9 seats for the justices up there. It's a slightly curved bench. And in the center, there is a podium, and the advocates are very close, just as they were in the other courtrooms. I think when Taft was working with the architect, Cass Gilbert, they wanted to recreate the intimacy of those other 2 courtrooms. So while from the back, it looks like a very large space, when you are standing at that podium, you are just a couple of arm lengths away from the justices themselves. So we have only one president left who argued in the Supreme Court. And if we go on to the next screen, you'll see it was Richard Nixon. And this is a turning point in his life. He had been vice president of the United States. He ran unsuccessfully for president in 1960, and he failed to be elected governor of California soon thereafter, and he's miserable. He feels like he's now lost his way politically. He had a friend, an associate, a young lawyer named Len Garment, who was located in a law firm in New York, and said, Nixon, why don't you come east, hang your hat here for a while till you figure out what you want to do. So no sooner does Nixon arrive when a client comes to the firm, and it's the Hill family. Who are the Hills? Well, back in 1952, this is 15 years before the case even gets to the Supreme Court, James Hill and his wife and 5 children were taken hostage by escaped convicts. They were held hostage for 19 hours. The family was unharmed, but when the convicts left the home, they were apprehended by police and 2 were killed. And so it was very traumatic for the family, and they didn't want any kind of publicity. But a year later, an author, Joseph Haynes, decides to write a book, a novel, a fictionalized account called Desperate Hours. And the year after, it was such a successful book, he makes it into a play. In 1954, it opens on Broadway. It wins the Tony Award for the best play of the season. And who appeared in the play? Paul Newman. So it gets the attention of Life magazine, and they write an article about it, basing it on the Hills' experience. They actually went to the Hills' home outside Philadelphia, taking pictures, and the family is distraught. And so they sue Life in state court in New York, and they win, and they get a lot of damages. And Life decides they're going to appeal the case to the Supreme Court. And Leonard Garment was going to do the case. And then Nixon comes along and he says, you are the ideal person. This is a case, you don't really like the press. Here's your chance, to have at them. And so Nixon agrees. And for a couple of weeks, it's a while since he's been in a courtroom. And he memorizes the trial record. He reads all the articles that he could, law review articles. He does what we call a moot court, where he practices arguing. He just total concentration. And when he came to argue in April of 1966, the Chief Justice then was Earl Warren, someone he considered his nemesis, another Californian, and he was terrific. The justices asked him 30 questions. Back in the early days of the court, it wasn't until after the Civil War justices asked any questions at all. But by now, the justices are engaged. They were interested in his argument, and he was very responsive. And he got rave reviews from members of the court, and even the Washington Post noted how well the argument went. So he felt good about the case. So after oral argument, the justices go into conference and they take a preliminary vote and an opportunity to exchange ideas. Unexpectedly, the court decided they wanted to have a re-argument, and they can do that. It's their prerogative. And it was the following October, the height of election season. And Nixon is now engaged with trying to help the Republican Party gain congressional seats. So he didn't do quite the same amount of preparation, but nonetheless, he re-argues the case. And in January, the decision comes down, and the Hill family, and who he's represented, has lost. It was a 5-4 decision. And Nixon took this so much to heart that what did he do that night? He sat down and dictated what became a 5-page assessment. What were my strengths? What were my weaknesses? He was always wanting to learn something from these unexpected consequences. Well, turns out about 20 years later or so, a book comes out, The Unpublished Opinions of the Supreme Court. And there's reference to the Hill case, how it changed. And Nixon calls Leonard Garment, says, investigate, I want to know what actually happened in that case. It was still bothering him that he'd lost. And it turns out that after the first argument, Abe Fortas, who was on the court at the time, persuaded the court 6-3 that the Hill family, that the press really had gone beyond what was acceptable. But who also was on the court at the time? Hugo Black. And he was an absolutist when it came to freedom of the press. And between his efforts and his conversations with members of the court, he persuaded them for a re-argument. And you can see it changed a couple of votes. Now, this is not uncommon. It doesn't happen often. But I know, for example, Justice Kennedy, when he was on the court, he was in the majority. He was writing the opinion. It turned out to be 5-4. And as a result of writing the opinion, he changed sides. So totally flipped the case. So, what goes on in conference, once you've argued, you wonder what happens. So there's a lot of discourse that happens even after oral argument. So I don't know if that made Nixon feel any better, but I do know that there was another case that the court heard in the mid-70s where the court did say that private individuals, as opposed to a person who had a public persona, should be given certain protections against press intrusion. But unfortunately, these cases do have consequences. And Mrs. Hill had been traumatized. She was rather fragile mentally. And in 1971, she took her life. So I'm sorry to end this particular case on that sad note. So those are all the presidents who've argued in the Supreme Court. And I'd like to close by just putting forth a question. Do we think that the Supreme Court changed, had an impact on the presidents? And did the presidents have an impact on the court? And I think we could say both. The presidents themselves, they realize not everything can be solved legally. Sometimes you have to take political action. It established reputations. Look at James Garfield, very personal. For Taft, he could do more for the court as Chief Justice than he could as president. And for Nixon, maybe losing even, but preparing, and he got that positive feedback initially. Maybe that gave him some confidence or drive to go back into politics. And then how did the court change? Look at the cases, some of these significant landmark cases that still resonate today. Fletcher v. Peck, Amistad, Milligan, that involved civil rights and liberties and other protections. So I think it is very much a mutual situation where both the court as an institution and the presidential advocates as individuals were changed. Because ultimately, as someone wrote, and I would agree with this, that law mirrors the issues, institutions, events, and people that have shaped American history. And I think Grover Cleveland probably said it best for them all. He said, "I tried so hard to do right." So I'm happy to answer questions. Thanks for listening.
Thank you very much. There's definitely there's a lot of information there, but a lot of very fascinating US history that's tied up, especially in the 19th century in the Supreme Court. So to remind people, we are just about at 5. So if we'll just do a couple of quick questions, and you're welcome to send emails or ask questions after the fact if you have any other questions. But we'll do a couple quick questions now. Again, you can type them into the chat or press the participants at the bottom and raise your hand, and then I will call on you, and that'll happen. I had a question about Garfield, about how Garfield died, apparently, how he died of infection, poor hygiene, which I thought was an interesting question.
Yeah. He was, has anyone, if you ever go to the National Gallery part on the mall side, closer to 6th Street, there is a plaque there that shows where he was actually shot by an unsuccessful office seeker, Gautreaux. And that case, I think, went to the Supreme Court too. But yes, he languished in the White House. They didn't have any sanitary they were digging, trying to get out the bullet. Alexander Graham Bell was called to try to extract it. There's a wonderful book about this. I forget the name of it. I can try to find it if whoever is interested, but he didn't have to die. He didn't have to die.
Thank you. Did you have a favorite case that came up during your research? Or a favorite president that argued in front of the Supreme Court that you weren't expecting?
I won't say favorite. I'm very taken with Garfield because he was a reluctant lawyer. He was very dedicated. He was brilliant. John Quincy Adams is an interesting person too, because the law was not his ambition, but he was interested in making the world better. Public service was important to him. And for him to have 2 cases, I think in the court's history, if you look at presidential advocate, I mean, the cases that he handled had to be remarkable in setting precedents that we still live with today. Yeah, thanks for asking that. It's hard to have a favorite, you know, it's like they're all your children. How do you choose? And the other interesting thing to remember about the Supreme Court, the court doesn't choose cases. It waits for things to come to it. So that's why sometimes it can be a little bit behind the times and what's happening in society. But the fact that they were, these advocates were able to persuade the court to take positions that might not have been popular, you know, establishing rights for Blacks, that was, you know, they're making their own decisions. Hopefully still today.
Great. Well, I think we're just about out of time, but thank you again for sharing so much. And thank you all for joining in and listening. And I hope you can join us at a future event. And I'll send out the YouTube link probably tomorrow.
And if I may, Jonas, I'll put in a plug. The National Portrait Gallery has reopened. There are timed tickets, and it's a huge place. So I've been there, and I felt very comfortable. And I'm hoping when the Supreme Court reopens that you'll come to visit and have a chance to sit in the courtroom and hear the lecture hear more about the court. So wishing you all well, and thank you for being here.